Can you hear me now? Yeah. If the panelists can come back to the table, we have now 20 minutes for questions. If you can keep your questions short so we can have as many questions as possible. If I can open it to the floor, if you can speak loudly and clearly for everyone, and then I'll pass on the microphone.
Yeah, I have a question, a comment to Levi Cooper. I think that modern codification is not merely a piece of legal work. It is a manifestation of a vision about a state, about how the state should look like. I'm talking about the new kind of state that emerged the new centralizing states with their visions of social engineering and so forth. You mentioned the first Prussian code, the Allgemeine Landrecht. Well, it's all about undermining the political power of the landed elite. So, and we can find the similar drives in other codes, but all of this is hardly relevant to the Jewish codes, which there is no Jewish state, right? I mean, there is no vision about how the modern state should look like and about social engineering and all this stuff. So I'm looking for that missing link. If you can say a few words about it. If I may, a question for Thomas Krolasik, also another fascinating talk. I think if there is anything that manifests the new legal culture that was brought about with codification, it's the code of procedure. It's new ideas about legal positivism and so on. You can even say the positive is the formalist obsession. It's all there inscribed in the procedural codes. So I wonder if you can say something about the impact on the Polish court system in terms of legal culture. In other words, did it change the legal culture towards legal positivism as it was in other places? Thanks.
Thank you very much for the comment. If I understood what you were saying, you're saying that there's really no, you can't make the comparison that I'm suggesting because state codes have a vision for the state, whereas the Jewish code, as Jewish codes are religious codes, and they don't have this overarching state vision. And I think that's the reason why until today they haven't been connected, because they are difficult to compare. And I certainly accept your comment. Having said that, you also mentioned the vision of social engineering. The Jewish codes do have that aspect, not on a state level. You're 100% right that I can't compare them with the vision of a state, but they do want to have an aspect of social engineering. And what's fascinating about when you compare the codes, I haven't found any similarity in the norms, but in the introductory material, when they explain why they're going to codify law, the similarities are fascinating. And to see someone say, we are codifying because we would like to. Nevertheless, I would like to make an argument that we may be able to talk about some type of similarity despite the gulf that you've pointed out. Thank you.
And on the impact of this code procedure civil on Polish legal culture, of course, I think it was even more than only code procedure civil, because of the fact that first time in our history we had new professional courts and a new hierarchy of courts. From the, let's say, 3-4 stages. First time the judges had to be professional officials who had a proper education. And another thing is that we had a much bigger need for professional attorneys. And of course we had a very good written law taken from another Western country, which of course had, in my opinion, wider and longer legal tradition. Of course, in Poland we had our Polish law, and we have lots of theses about it. But I think that I think the Western law was better. Now Polish law is based on French and German law, especially civil law. So, of course, for the first time from 1808, our courts, it was a huge struggle just to enforce the new code, because no one could use it. It was very difficult. The attorneys, judges, prosecutors, all of these people, they had to learn it. They had to study how to use it, and very often they use it in the wrong way, or sometimes they took some Polish institutions and they weren't applying it as properly. But when it was being changed after the fall of Napoleon, it was another problem, that they were bit to that. They wanted to use it. They wanted to use it rather than, for example, Russian, German, or Austrian law. That's why the Napoleonic Code. That's why French Code de procédure civile were so popular, and one of them, it lasted till 1876. On the other hand, lots of institutions which were in the Napoleonic Code, they survived till nowadays. Nowadays, the institution of komornik, so of bailiff, it looks very, very similar how it looked back then.
Thank you, Tomasz, and thank you for your presentation into a very specific and practical area. Any questions for Hugo or Piotr before we continue? Yes.
Thank you. I do have a question for Piotr. I found very interesting what you were saying about the many conflicts arising as a consequence of the introduction of French law into context where there wasn't any social revolution before. And I found that very plausible. But then at the very end you said that there were many areas of civil law where there weren't any conflicts at all, for example, marriage law or many other things. And then I was wondering if you had any explanation for why there was just in this field of feudal duties, property questions, why it was there that so many conflicts arose. Maybe marriage law, something very sensible as well, linked to Catholic religion as well. So I was wondering if you had any explanation for why it's especially this kind of law that was so problematic.
I think it was from the political reasons. We must note that the Duchy of Warsaw, in the Duchy of Warsaw, this group, a state maybe, who rules, it was the nobility. In the France, it were bourgeois. Bourgeois, the people from the new families, people who take a big political position during the revolution. In Poland, the political elite, it was the same people who rules, for example, in the times of the same Wielki, great Detyni, so from the times of our reforms, which took place after the second and third partition, so in the end of the 18th century. And for this ruling elite, the base of their economical status, it were these feudal duties, and they stopped to destroy of their own properties because it was their economical interest. But, for example, Catholic Church was not so powerful and couldn't stop to the secular marriage law. And, for example, divorces were in Duchy of Warsaw maybe not popular, but the scale of this phenomenon was rather wide. And I think this for my question, for my answer to this question.
Do we have a question for Hugo? Or for any other? Yes.
Thank you for your extremely interesting presentations. My question for the first speaker is about your conception of patriotism. Does it have any elements of national consciousness or something contradictory in this admiration of France? Then French army actually is occupied with motherland.
I think culture is the key to understand the transition between the coming of French troops in the Neapolitan Republic, but it's not only a question of imposition. It's like dialogue. It's like a dialogue between the patriots, the elites, and the French. They are in invasion with France, and they want to keep the French ideas for their own constitution or project in the future, like a penal project or a civil project. I don't think there is a contradictory between the invasion of France and the admiration of culture, because they want to give to their own countries their how can I say in English?
What's in French?
Alors, je perds mon boulot. They want to adopt the concept, French concept, because they think they are very, very good. So the admission is the first time is easier. Is not the army is it's a second point. It's a second point. So I think there is a very important relation between loving this admiration and the conception of writing a constitution.
Any other questions to any of the panelists? Oh, we've got two there. Please.
I was wondering first, it's just a slight comment about the missing link you mentioned. When comparing so different legal traditions, we need to think first about the common frame of reference and for the purpose of this comparison. If we would compare Jewish religious tradition and state French legal tradition, that would be hard to find the tertium comparationis, as the comparators would say. But if we posit on a slightly wider perspective and talk about different legal traditions and take as example as a principle, methodological principle, the functionalism as approach, looking for the functions that legal tradition perform in society, then that kind of approach might justify the comparison between the so very different codes and the ideas of codes. So that might be the missing link that you would like to accentuate to explain the discussion with those lawyers who understand law as Western European law, right? As continental law or Anglo-Saxon law and common law.
If I could add to your point, Dimitri, I think that you spoke about different legal I think you're talking about different legal theories or approaches to law. I was even and I accept your comment. I was also talking about just different writing styles. What's the style of how we present different types of legal literature? What's the style that will present the law? And that's why I presented at the beginning of my presentation. I spoke about how there was 200 years where codes of Jewish law were not written. What suddenly happens at the beginning of the 19th century? even given the vast differences. So I think that your approach is also...
Yeah, but then you will have to ask yourself whether, the modern code and, I don't know, the Tang code or the Jewish code of the 16th century belongs to the same category. Well, it might not, it's just whole two different things. The fact that you put, these are compilations of law and this is codification. What makes it codification is the fact that, it's a claim for sovereignty of the state. I mean, can we talk about the code without the states?
I think so.
I mean, there is a way, there is a way out if you can prove or demonstrate in fact that they are playing with the idea of, we are imagining our state or a Jewish state, which I know it might be quite difficult.
That I can't do, but I think there are other ways as well. If you talk about codification as being something like a comprehensive presentation of law, if that's the way you define codification, there's a lot of I'm sure you know, right? There's a lot of there's a lot of literature on what defines a code.
No, but the problem is historization of this whole thing, because you can talk about everything as code. There are so many laws that are written. That make them codes, and even laws of states, pre-modern states that are written. And there are certain features of codes that are not there, and I don't know if they are in this what you call codes. So it's something that goes back to the question of history. Is this, if you take that as a framework, you can compare everything to everything else, but we are trying to historicize the whole phenomenon, and that's the problem.
Did you had a comment on?
Yes, I had a comment to the same topic because I'm dealing also with a codification which has nothing to deal with the state. And I think it's different between private law codes and some other codes, because in private law, yes, it can be one purpose of the code can be modernization, but it is not always. For example, in the same Russian Empire, in the Baltic provinces, there was also codification. It has been called a modern codification. It isn't, and I'm dealing with the problem, but still it is a codification. It is a summary of private law norms which are valid. And in that sense, the codification is pretending to be a codification.
We have only a couple of minutes before we have to go to lunch. I assume this is going to continue into lunch and through a whole discussion about codification. A final remark, please. Sure.
Yeah, what I was wondering, because you presume a lot of information, that we have a lot of information about these Jewish codes, but I suspect that, as myself, a lot of us don't. I do think that the comparison between, what I wonder is, maybe code is a bit difficult to say, but you can, for example, also in Dutch discourse, I can see people making privately attempts at codification, knowing that there's no state, because there are some promises and all other difficulties, but just making sort of a private example of it. But do you see differences in style between, for example, compilation? Because I don't think you can use the modern term of code on 16th century compilations. Do you see a difference in style in, for example, trying to make one source of it, and also, between the sort of early 19th century writings and the 16th century compilations?
I'm not sure if I understood your question, sir.
Do you see a very different style of approach to presenting the Jewish law as one codification in the early 19th century, as opposed to the 16th century sort of compilation?
I don't find a very different style in the way it's presented, but in the reasons that they are approaching the codification, their justifications, the rhetoric, the narrative that surrounds the codification is different in the 18th century as opposed to the three codification efforts in the end of the 16th century.
We're going to have to finish here, but clearly this panel has created a lot of food for thoughts. We are now moving on to lunch, but first I would like you to join me in thanking our presenters for their very interesting much.